The appointment of 11 new justices of the Supreme Court was hailed as a significant milestone in the Nigerian judiciary that has suffered knocks in recent months due to integrity issues. Is the appointment of the new justices about making the numbers or about quality justice delivery for the Nigerian public? Godfrey Eshemogai has more.
Nigeria now has the full complement of 21 Supreme Court justices as required by the Constitution, a feat that is worth noting. This had seemed unattainable until the current Chief Justice of Nigeria, Olukayode Ariwoola, committed to breaking the seeming jinx.
The inability of the court to meet up the statutory full complement of 21 justices had lingered on for too long, thus appearing to be like a jinx. I therefore made a categorical pledge that before I finish my tenure as the Chief Justice of Nigeria, I would, by the special grace of God, do everything within my ability to break that jinx and get on board the well-deserved full complement of the court.
Amidst mounting workload across the courts, the country's apex court, too, hasn't fared any better because it had been short of staff to get the job done. As for several months, less than half of the required workforce had been working their socks off. For several months, only 10 Supreme Court justices did the job of 21. The 10 are the Chief Justice of Nigeria, Olukayode Ariwoola, Justice Kudirat Kekereekun, Justice John Okoro, Justice Uwani Abba Aji, and Justice Lawal Garba. Others are Justice Helen Ogunwumiju, Justice Ibrahim Saulawa, Justice Adamu Jauro, Justice Tijani Abubakar, and Justice Emmanuel Agim. Justice Olukayode Ariwoola, who in August this year turns 70, will be bowing out of the judicial scene. He had paid his dues in the Nigerian judiciary, having played key part in a number of notable cases, including being a member of the Supreme Court panel that affirmed the election of President Muhammadu Buhari for a second term. Justice Kudirat Kekereekun, who was born in London, was the apex court justice who read the judgment that sacked Emeka Etiaba as Imo State Governor and declared Hope Uzodinma winner of the election. Helen Ogunwumiju is another justice of the Supreme Court. She was part of the apex court panel that affirmed President Muhammadu Buhari's victory for a second term. There is Justice Lawal Garba, who was also part of the panel that affirmed the then President Buhari's second term election. And there's Justice Emmanuel Agim, who in a lead judgment stated that the extraordinary rendition of Nnamdi Kanu, that's leader of the indigenous people of Biafra from Kenya, doesn't clear him of charges for the trial he was facing before he left the country. The other justices of the Supreme Court have played very crucial roles in deciding electoral, constitutional, civil, and criminal matters with all sense of duty and commitment to keep the wheels of justice turning despite all the odds. The appointment of 11 Supreme Court justices is indeed a breath of fresh air for the Nigerian judiciary. For starters, Justice Hannatu Jume Sankey, one of the 11 Supreme Court justices, headed a 3-member panel of appeal court justices that quashed the terrorism charge against the leader of IPOB, Nnamdi Kanu. The court ruled that his forceful rendition from Kenya violated international conventions and treaties. There is Justice Haruna Tamani, the former appeal court justice who headed a panel that upheld the federal government's application for stay of execution of the judgment that had previously set Nnamdi Kanu free. Justice Tamani was also chairman of the Presidential Election Petition Court, which affirmed the election of President Bola Tinubu. Justice Stephen Ada is another name to note. Justice Ada was among the 5-member panel of justices who affirmed Bola Tinubu's election in the presidential polls. Justice Mo Adumain has been involved in several significant legal matters. Recently, he was head of the appeal court panel that upheld the judgment of the Kano Governorship Election Petition Tribunal that affirmed APC candidate Nasiru Gawuna as winner of the Kano State Governorship election. Another name is Justice Chioma Nwosu Iheme, who then, as judge of the Imo State High Court, presided over the Otokoto saga, which involved the gruesome killing of a miner who was lured into the notorious Otokoto Hotel by criminals. There's Justice Jamilu Tukur, who in 2019 delivered the lead judgment of the Court of Appeal in Lagos, declaring the imposition of fines by the Lagos State Traffic Management Authority, LASMA, as illegal and unconstitutional. Justice Obande Ogbuyinya, one of the 11 new Supreme Court justices, had in a dissenting judgment challenged the Kogi State Governorship Election Tribunal's decision regarding the then governor Yaya Bello's participation in the election. With the track records of those that now make up the Supreme Court bench clearly ruled out, things are likely to take a positive turn as far as the Nigerian judiciary is concerned, even though these are early days yet. Godfrey Eshemoge, Arise News.
Joining us now from Port Harcourt in Rivers State is Emeka Etiaba, a senior advocate of Nigeria. Good morning, Mr. Etiaba SAN. Good to have you on the morning show.
Thank you, Ruben, and your crew. I say good morning.
Morning, sir. Well, very quickly, you listened to, our introduction of this subject. How significant is the fact that since 1999, the Supreme Court of Nigeria now has a full complement of 21 justices as stipulated in Section 230 of the 1999 Constitution in terms of performance and efficiency and keeping the dockets moving quickly?
Thank you, Ruben. Viewers, good morning. It is a cheering news that the Supreme Court of Nigeria now has 21 justices, a full complement. Again, I'll start by thanking the CJ and the Chief Justice of Nigeria who made a promise and fulfilled it. I'll also thank the President of Nigeria. Some senior lawyers have kicked against such salutation, but I do not reckon with such criticisms because the ones who were in this country when a CJN was removed by ex parte order and heavens did not fall. So if you see a president that has done well or a public officer that has done well, you should say you have done well. So I say to the president he has done well. If he did not cooperate with the judiciary, I know that today wouldn't have come. And so thank you to him. I also say thank you to the Attorney General, under whose watch, recommendation, and hard work, such a full complement of the Supreme Court has been achieved. And so, having said that, I'll go straight to say that the Supreme Court is set on a new trajectory. This trajectory, we can see, as far as I'm concerned, the foundation started with the last set of judgments of the political judgments that we had, where they did justice to all without exception of all the cases, governorship cases that came before them. And you remember that before now, they were only 10, out of which 9 managed all the political cases. Now they are 21, we expect a lot. But I will also tell us that, of course, it's not Uhuru yet, because even the new justices that have come in, some of them sat in the cases that are coming up now for adjudication at the Supreme Court. And so you find out that day after day, one justice or the other may be eased out of a panel for another justice to come in so that he doesn't sit on on appeal over a judgment he was a part of at the lower court. And so you will still find some little issues here and there, scheduling of panels and all that. But we expect quite a lot. The Supreme Court Act, Section 3.1, says that a panel will be made up of not less than 5 members. And now there are 21. You can expect the Supreme Court at the minimum to do 2 panels a day and has the capacity to do 3 panels a day. And so things will be hastened up. We believe that justice will be dispensed even better now. And then the ones who also did not have their vacation, who toiled day and night right from the general elections till date, will now have time to at least cool off for 1 month or so before they get back to the tedious work of adjudication. So they are coming in. The coming in of the new justices will also pave way for these justices who have toiled quite a lot without rest to go and have some rest and come back and join. It's a good one for the judiciary, and we thank God for today. We really thank God.
All right. Excuse me. Mr. Etiaba, while we're speaking on efficiency, so the backlog currently is 6,884 delayed cases. Are you sure that hinging our hopes that this machine will become well-oiled on a full bench, are these hopes not a little bit too optimistic? You look at the 2022-2023 legal year, of course, with just nine justices, it was 1,271 cases that were handled. So you look at the new cases that will be instituted, added to the 6,800 that are already there. It seems a lot more needs to be done than a full bench in order for the Supreme Court to become a well-oiled machine. What are those changes that need to happen for us to see this efficiency beyond manpower? Because it's clear that there's more than manpower that's required.
Yeah, thank you very much. I think that there's a limit to what 21 men can do, but at the same time, at all, I was pass, there must be a marked difference. But I'll tell you that what is remaining, as far as I'm concerned, will have to do with constitutional amendment, so that little things, interlocutory matters, land matters will not have to get to Supreme Court. Matters ordinarily that can terminate at the Court of Appeal should be made to terminate at the Court of Appeal. There's no reason why matters like interlocutory matters should come to Supreme Court. And then, of course, we are large enough now to think about, if we won't have state Supreme Courts, we can have regional Supreme Courts. Nothing wrong with it. It's just that we're concentrating everything at the center. Nothing prevents us to have, we have 6 regions as recognized politically in Nigeria. Nothing prevents this country from having regional Supreme Courts if we cannot have state Supreme Courts. Because a situation where, for example, Igbo customary law, a matter hinges on Igbo customary law, and it comes to Supreme Court where probably the justices that will sit over the matter are not even from southern Nigeria. What do they know about customary law of Nigeria, of Igbo land? So there's need for constitutional amendment also, so that Supreme Courts will be regionalized, and then you still have the one in Abuja there, to handle certain matters and issues. And again, it's also good to also make it, put more stringent punishments on lawyers who bring irrelevant cases to Supreme Court. For example, Supreme Court has original jurisdiction over matters between states and federation, states and states. And then you find a council who brings a land matter because a state has been cited in it, brings it to Supreme Court and takes the whole day to argue issue of jurisdiction and all that. So if sanction also is attached to actions of lawyers, frivolous matters will not come up to Supreme Court. I've just given an example. And so there's need for constitutional amendment to wit, redefining matters that should make their way to the Supreme Court. When, in times past, National Assembly challenges, political cases, election matters used to find their way to Supreme Court. But when Section 463, I think, 4653 of the Constitution was enacted, National Assembly matters now stop at and State Assembly now stop at the Court of Appeal. So that takes a whole lot out of the Supreme Court docket. That can be also fashioned in other areas, other matters that must not come to Supreme Court.
Okay. Good to see you again, sir. I mean, let's now talk about the main thing.
Thank you.
The quality of judgments. While we had that profile being reeled out, we saw a lot of judgments that were really suspect. I can go through these judgments. The Imo one, you know, a lot of other judgments given. We now have a case where justices now have to defend their judgments in public by reacting to criticisms of their judgment. I mean, the quality of judgment. With this 21 complement, are we going to get the quality right? What is even the quality of personnel on the bench? It's not by getting the full complement of 21, but what's the quality of this judgment that a lot of people have, you know, raised eyebrows about?
Okay. As far as I'm concerned, Supreme Court is final not because they are infallible. It is because the buck stops on their desk. That's why they are infallible. And I can tell you that I've not seen a situation where a Supreme Court judge went out there to defend a judgment Supreme Court delivered. I don't think it has ever happened. There was a one-off of a Court of Appeal justice who strayed that way. And I think there was an uproar on that. But having said that, I believe that we're all human. You know, we can make mistakes. But what I disagree is the fact that a judgment cannot be reviewed. If we agree that we're human beings, that we can make mistakes, and these mistakes are not predicated on anything but maybe that minds were not adverted to one or two things, and eventually a call for review comes within the law, I think whether it is Supreme Court or it is the Court of Appeal, they should review these judgments. The provisions have been made for review. And then talking about the justices that have come up, yes, one or two justices, on complimentary things have been said about them. In some cases they handled. But remember that when you handle 100 cases and fault is found in one, I don't think 1% is enough to say that the man never does good or the woman never does good. So much as it is not good to hear, it's also good to realize that they are human and they can make mistakes. I would wish to encourage them to be more discerning, more diligent in their work. I'll also tell you that part of the problem we have, even at the Supreme Court, is that these days you find judgments that run up to 200 pages, 100 pages. You know, these judgments, since there are no appeals on them, maybe it will serve the public better. Maybe it will also serve them better to give us judgments that are not up to those pages. I mean, in times past, you read the West African Court of Appeal report, that's WACA, you read the judgments of the 60s, 70s, 80s, you find out that these judgments are within 5-6 pages, and they are solid. Everything that needs to be said are said. You know, probably the justices of today do what they do because lawyers will say, "Oh, our issues were not. We canvassed this. They didn't say anything about it, and all that and all that." But the important thing is to do justice and make sure that those issues that call for determination are pronounced on. So maybe part of it is to reduce this volume of writing that are done, you know, and go ahead, like as in times past, give judgments that deal with the issues and deal with them soundly. So I want to believe that the crop of justices that have just moved into the Supreme Court, looking at what the ones that they have met have done recently, I do not have a doubt that they will conform, because it's about leadership. It's about leadership. If the leadership is doing well and sets good example, the led will follow. So I think some of them who have had some uncomplimentary things said about them will look at the ones they have met at the Supreme Court in this season and learn. Wow. And the Chief Justice of Nigeria has also not left anybody in doubt that he wants to leave on a high, on a good note. And that is partly why he insisted and fought for this full complement to be brought to bear. So it's a thing of joy, and I'm very excited. I'm really very excited that cases will receive more attention now than ever before.
Well, sir, I'm sure many lawyers will agree with you that the Supreme Court of Nigeria should be a proper policy court, rather than a court where all kinds of matters are taken to. And you are absolutely right to say that lawyers should be disciplined. Lawyers who abuse court process and bring frivolous cases before the apex court. But there are two other issues that I would like you to comment upon. One, the process of appointment. These, justices were appointed just by voice vote by the Senate of the Federal Republic. In other jurisdictions, they have public hearings. People who have issues. Yes, you mentioned two justices against whom issues were raised about cases that they are determined. I don't want to mention their names, Now, if there was a public hearing, those persons who have issues with them could have come forward, to say, oh, this is how we feel about these persons. The second issue has to do with the fact that in 2017, the NBA insisted on the national judicial policy and the rules of procedure for appointments to the apex court, that it should be left open. Senior advocates should be recommended, academics should be recommended, as is the case, say, in the US and Canada. But here, the concern is that promotion to the apex court in Nigeria has become almost a guaranteed thing. Once you are in the court of appeal, you almost get automatic promotion. And there are many lawyers who are saying, no, it shouldn't be like that. After all, Taslim Elias, to cite one example, Justice Taslim Elias, came from the academics. Justice Inamani came from practice. So why is it that now it's like a secret society promotion from the Court of Appeal to the Supreme Court? Those two issues.
Okay, thank you. First of all, let me start from the back, the second issue you raised. Those of us who are lawyers, legal practitioners, have raised this issue again and again. And it is more like it is between us and them. That's the treatment from the judiciary to the lawyers, between us and them. They will not come in. And I've had opportunities to canvass this case even before one or two justices, and I believe I made sense. When we canvass that senior advocates should go to the Supreme Court bench, we're not talking about every legal senior advocate. And we're not talking about every. The ones that we will readily come to mind are people, senior advocates, who are worth their onions. They have made the name. They are known to be repository of the law. And most importantly, very respectable in the society. I'll give you an example. When the name of Chief Ola Olanipekun was, SN was muted, Dr. Olisa Abakoba SN was muted, Chief Tony Digwe, can you fault any of these three? Can anybody come out and say any of these three will not acquit themselves at the Supreme Court? What are they going there to do? Some people think, they want to go now and enjoy. Enjoy what? What is there to enjoy? Have you ever seen a Supreme Court justice fly a private jet to a meeting, either in the country or outside the country? But these lawyers are lawyers who, on their own, from their pocket, they fly jets, private jets, just to attend meetings and go back to their homes. So what is there to enjoy? Enjoy how much? To be bought a Mercedes or a Jeep or what? It is a sacrificial thing. If the type of senior advocates we're thinking about are to join the Supreme Court, that will be very sacrificial of them. And then these are people who have looked at themselves and there's nothing to conquer anymore in practice. And they see a need to go and help. And you're telling the advocate, no, if Taslim Elias failed, if Nnamani failed, then you can make a case. But these are people who went and till date, their records are speaking for them. So on what basis? But I also remember that sometime when the Bar Association submitted names of senior advocates and senior lawyers that could go to the Supreme Court bench, I also remember that some one or two names were added to those names. You know, people who ordinarily, I personally will not be happy to see in that bench because they have nothing to offer. You know, so that is the abuse that can come with it. But then we know those who qualify, and those of us who know those that qualify will ensure that if opportunity is given, it is those names that will go in. You know, that's basically that. I leave it at that. And then on the second one, I do not see the reason why, if I want to be a senior advocate, my name will be published in the paper, and then public comments are invited, and I'm scrutinized, interviewed before I become a senior advocate. Whatever I do, I'll be doing as a senior advocate from my office. And then a judge who will pretend over the lives of the people. A judge that will pronounce somebody to be hung will now be appointed without any scrutiny, without the public commenting. If the public was commenting, many judges today will not be judges because people who know them will speak out. So there's need to change the way appointments are made. There's need to make it more open. If you know the candidates, the aspirants that have brought in their application, I call them aspirants because that's what they are at the point of submitting their application, and then their resume come in. So you publish it, you invite people to make comment, and then you will hear who they are truly, you know, and then you know whether they are qualified to answer my lord. Because that my lord, I can't answer my lord now. How can I answer my lord, no matter how smart I am as a lawyer? But once I wear the judge's wig and I sit there, I become my lord, and I'm next to God. That's what it means. I'm next to God. So who you will promote to that level must show that he is worthy to be there. And then you now talk about other considerations. The Nigerian Bar Association, we go to court every day. We know the lawyers who can make the bench. When you hear that this branch of Nigerian Bar Association names have been forwarded to them, or they have been told that there will be that there will be recruitment, it is just to fulfill all righteousness. The names that will go in have been selected. You know, so we should tell ourselves the truth. Involve lawyers in what we are doing. Involve the general public. Involve even the litigants because they know what they have seen in the hands of lawyers, so they can make comments on such characters. You know, that's my take on it. There must be a way to change what goes on. And then you talk about recruitment of judges in states. What has NJC at the federal level got to do with recruitment or lawyers, judges in Anambra State? Who do they know? It still boils down to who can get to Abuja. You know, so some of these things should be left at state level or regional level so that the more you are closer to the grassroots, the more you know who is who. But once it comes up there, you'll be hearing from the governor. Governor tells you who he wants and who he doesn't want. And then you can hardly go away from the governor's choice. And tomorrow they will say, the judges are pandering to the governors. Because he who pays the piper dictates the tune. If they know who appointed them, then I tell people that, you know, corruption is not only when money is involved. When you have somebody who bears this influence that cannot be stopped, it's worse than money. When somebody appoints you a judge, he cannot call you in the morning and tell you what to do and you will not do it. You can resist money as a person, but the other one, it is more difficult. You know, so you leave the fate of the judges, incoming judges, with the people to determine. And then when the judge knows that the people determine my fate, they will be loyal to the people.
All right, Senior Advocate of Nigeria, Emeka Etiaba, thank you so much for your contributions. Very quickly before we go, you know, as you mentioned the discrepancies in the system and some of these peculiar ways in which these justices are selected, we know one of the biggest issues is a public trust deficit. Very briefly, how do we then repair the public trust deficit when you're painting out this picture that already shows that the process to get there is not free, fair, or transparent. So how will the judgments become free, fair, and transparent? And how do we win back the trust of our nation?
Well, the way to win back the trust is for the ones who have been appointed judges and justices to do justice. Like we saw, like I will always say, like in the last set of governorship judgments that came, over 12 of them, nobody complained because we know that the people voted for are the ones that are in the office today. So that's one of the ways. Make sure that if you are in, you do justice. The other one is to make sure that you, the appointers, get in the right people. And when the people feel that the right people are not on the list and they protest, you listen to them. For example, the immediate past governor of Kogi State went ahead to forward names of about, I think, 10 or 12 potential judges to fill in spaces in Kogi State. I hear the wife is one, and the others. Some senior advocates from Kogi State came together. There was no divide, and they petitioned. And of course, that has been scuttled, you know. So that's a way to show that the system is also working, it's under check, you know. There's a sad one that is coming from FCT where somebody sued and he was told that he doesn't have a locus. Of course, that one I cannot comment because it will end up at the Court of Appeal and probably Supreme Court. But if the system allows itself to be scrutinized, criticized, and reinvigorated, the public trust will come. I believe that for now we are on the right path, except we start getting it wrong again. But most importantly, the executive must try to stay clear of judiciary. Can they do it? Can the political class do it? That's a question.
That is the question.
Answer. But that is a major issue.
That's the major issue, absolutely. Emeka Etiaba, Senior Advocate of Nigeria, thank you so much for your insight today.